prosecution will next take up the responsibility of the defendant, Martin Bormann. The presentation will be made by Lieutenant Lambert.
May it please the tribunal, the prosecution comes now to deal with the defendant Bormann and to present the proofs establishing his responsibility for the crimes set forth in the indictment. And if the tribunal will allow, we should like to observe on the threshold that because of the absence of the defendant Bormann from the dock, we believe that we should make an extra effort to make a solid record in the case against Bormann out of fairness to defense counsel and for the convenience of the tribunal. I offer the document book supporting this trial address as USA Exhibit JJ, together with the trial brief against the defendant Bormann. The defendant Bormann bears a major responsibility for promoting the accession to power of the Nazi conspirators, the consolidation of their total power over Germany, and the preparation for aggressive war set forth in count 1 of the indictment. Upon the record of this trial, the Nazi Party and its leadership corps were the main vehicle of the conspiracy and the fountainhead of the conspiracy. Now, following the flight of the defendant Hess to Scotland in May 1941, Bormann became executive chief of the Nazi Party. His official title was Chief of the Party Chancery. Before that date, Bormann was Chief of Staff to the defendant Hess, the deputy of the Fuhrer. By virtue of these two powerful positions, Chief of the Party Chancery and Chief of Staff to the deputy of the Fuhrer, Bormann stands revealed as a principal architect of the conspiracy. Subject only, and we stress subject only, to the supreme authority of Hitler, Bormann engineered and employed the vast powers of the party, its agencies and formations in furtherance of the Nazi conspiracy. And he employed the party to impose the will of the conspirators upon the German people. And he then directed the powers of the party in the drive to dominate Europe. Accordingly, the defendant Bormann is blameworthy for the multiple crimes of the conspiracy, for the multiple crimes committed by the party, its agencies, and the German people in furthering the conspiracy. It might be helpful to give a very brief sketch of the career in conspiracy of the defendant Bormann. Bormann began his conspiratorial activities more than 20 years ago. In 1922, only 22 years of age, he joined the organization Rossbach, one of the illegal groups which continued the militaristic traditions of the German army and employed terror against the small, struggling pacifist minority in Germany. While he was district leader for this organization in Mecklenburg, he was arrested and tried for his part in a political assassination, which we suggest indicates his disposition to use illegal methods to carry out purposes satisfactory to himself. On 15 May 1924, he was found guilty by the State Tribunal for the Protection of the Republic and sentenced to 1 year in prison. Upon his release from prison in 1925, Borman resumed his subversive activities. He joined the militarist organization Front Bond, and in the same year, he joined the Nazi Party and began his ascent to a prominent position in the conspiracy. In 1927, he became press chief for the party Gau of Thuringia. In other words, relating back to the case against the leadership corps, he became an important staff officer of a Gauleiter. On 1 April 1928, he was made district leader, Bezirksleiter in Thuringia, and business manager for the entire Gau. We come now to a particularly important point involving Borman's tie-up with the SA. From 15 November 1928 to August 1930, he was on the staff of the Supreme Command of the SA. Now, the tribunal has heard the demonstration of the criminality of the SA and knows full well that this was a semi-military organization of young men whose main mission was to get control of the streets and to impose terror on oppositional elements of the conspiracy. Our submission at this stage is that by virtue of Borman's position on the staff of the Supreme Command of the SA, he shares responsibility for the illegal activities of the SA in furtherance of the conspiracy. In August 1930, Borman organized the Aid Fund, Hilfskasse, of the Nazi Party, of which he became head. Through this fund, he collected large sums for the alleged purpose of aiding the families of party members who had been killed or injured while fighting for the party. As the tribunal knows, on 30 January 1933, the conspirators and their party took over the government of Germany. Shortly thereafter, in July 1933, Bormann was given the number 3 position in the party, that of Chief of Staff to the Defendant Hess, the Deputy of the Fuhrer. At the same time, he was made a Reichsleiter. And as the tribunal knows, that makes him a member of the top level of the alleged illegal organization, the Leadership Corps of the Nazi Party. In November 1933, he was made a member of the Reichstag. I request the tribunal to take judicial notice of the authoritative publication, German publication, the Greater German Reichstag, edition of 1943. The facts which I have recited in the foregoing sketch of Defendant Bormann's career are set forth on page 167 of that publication, the English translation of which appears in document 2981 PS of the document book now before the tribunal. With respect to Bormann's conviction for political murder, I offer in evidence document 3355 PS, USA Exhibit 682, which is the affidavit of Dr. Robert M. W. Kempner, and I quote therefrom briefly as follows. Quote, I, Robert M. W. Kempner, an expert consultant of the War Department, appeared before the undersigned attesting officer, and having been duly sworn, stated as follows. In my capacity as Superior Government Counselor and Chief Legal Advisor of the pre-Hitler Prussian Police Administration, I became officially acquainted with the criminal record of Martin Bormann identical with defendant Martin Bormann, now under indictment before the International Military Tribunal in Nuremberg, Germany. The official criminal record of Martin Bormann contained the following entry.
Could you go a little
Bormann,
bit slower?
certainly, sir. Sorry. Borman Martin, sentenced on May 15, 1924, by the State Tribunal for the Protection of the Republic in Leipzig, Germany, to 1 year in prison for having been an accomplice in the commission of a political murder. Signed, Robert M. W. Kempner. End of quotation.
Lieutenant Lambert, I don't think it's necessary for you, when dealing with a document of that sort, to read the formal parts. If you state the nature of the document and read the material part, you needn't deal with the formal parts. For instance, I, Robert Kempner, an expert consultant and all that. Do you understand?
Thank you very much, sir, for a very helpful suggestion. As Defendant Hess's Chief of Staff, Bormann was responsible for receiving and channeling up to the Defendant Hess the demands of the party in all fields of state action. These demands were then secured by the Defendant Hess by virtue of his participation in the legislative process, his power with respect to the appointment and promotion of government officials, and by virtue of his position in the Reich Cabinet. I come now, as it seems to us, to an important point which ties up the Defendant Bormann with the SD and the Gestapo. As Chief of Staff to the Defendant Hess, Bormann took measures to reinforce the grip of the Gestapo and the SD over the German civil population. I request the tribunal to notice judicially a Borman Order of 14 February 1935, set forth in the official publication Decrees of the Deputy of the Fuhrer, edition 1937, page 257. I quote merely the pertinent portions of that decree, the English version of which is set forth in our document 3237 PS, which reads as follows, quote, that is our document 3237 PS.
If you can summarize it, if it's a document of which we can take judicial notice, it's sufficient for you to summarize it without reading it.
I appreciate that, sir. This quotation is so succinct.
Very well, go on.
And so brief that it perhaps could avoid summarization. Quote, the Deputy of the Fuhrer expects that party offices will now abandon all distrust of the SD and will support it wholeheartedly in solving the difficult tasks with which it has been entrusted in order to protect the movement and our people. Because the work of the party is primarily benefited by the work of the SD, it is inadmissible that its expansion be upset by prejudiced attacks when individuals fail. On the contrary, it must be wholeheartedly assisted. Signed, Bormann, Chief of Staff to the Deputy of the Fuhrer. End of quotation. That is with respect to Bormann's support of the SD. I deal now with Bormann's effort to support the work of the Gestapo.
Well, Lieutenant Lambert, wouldn't it have been sufficient to say that that document indicates the support Bormann promised to the SD?
I was anxious merely on one point, sir, that a document was not in evidence unless it had been quoted.
Oh, but you began by asking us to take judicial notice of it.
Yes, sir.
If we can take judicial notice of it,
Then it
Then
need
you
not
wanna-
be quoted?
it needn't be quoted. That's what I was saying.
Grateful. Then with respect to Bormann's efforts to reinforce the grip of the Gestapo, I request the tribunal to notice judicially a Borman Order of 3 September 1935 calling on party agencies to report to the Gestapo all persons who criticize Nazi institutions or the Nazi Party. This decree appears in the official party publication, Decrees of the Deputy of the Führer, 1937, at page 190. The English translation is set forth in our document 3239 PS. 3239 PS. I shall summarize the effect of this document shortly. In its first paragraph, it refers to a law of 20 December 1934. As the tribunal will recall, this law gave the same protection to party institutions and party uniforms as enjoyed by the state. And in the first and second paragraphs of this decree, it is indicated that whenever a case came up involving malicious or slanderous attack on party members or the Nazi Party or its institutions, the Reich Minister of Justice would consult with the Deputy of the Führer in order to take joint action against the offenders. And then in the third paragraph, Bormann gives his orders to all party agencies with respect to reporting to the Gestapo individuals who criticize the Nazi Party or its institutions. I quote merely the last paragraph. Quote.
Well, I took down what you said in your first sentence,
Yes.
which was that the document showed that he was ordering a report should be made to the Gestapo for anyone criticizing the party. Well, that's sufficient, it seems to me, and all that you've said after that is irrelevant. Cumulative. Not irrelevant, but cumulative.
There is, however, one brief point, if I may be permitted, which I should like to emphasize about the last paragraph, because I think it is helpful on the prosecution's case against the leadership corps of the Nazi Party. The tribunal will recall that it asked certain very material questions with respect to whether the prosecution's evidence involved the rank and file of the leadership corps. In the last paragraph of this decree, Bormann instructs the Ortsgruppenleiter, and that's way down in the leadership corps hierarchy, underneath Gauleiter and Kreisleiter. Bormann instructs the Ortsgruppenleiter to report to the Gestapo persons who criticize Nazi Party institutions. Now, an important point with respect to the tie-up between Bormann and the SS. The tribunal has already received the evidence establishing the criminality of the SS. In this connection, I respectfully request the tribunal to notice judicially the July 1940 issue of Das Archiv, our document 3234 PS. On page 399 of that publication, under date 21 July 1940, it is stated that the Führer promoted Defendant Bormann from Major General to Lieutenant General in the SS. Accordingly, we respectfully submit that Bormann is chargeable and jointly responsible for the criminal activities of the SS. After the flight of the defendant Hess to Scotland in May 1941, the defendant Bormann succeeded him as head of the Nazi Party under Hitler, with the title Chief of the Party Chancery. I request the tribunal to take judicial notice of a decree of 24 January 1942, 1942 Reichsgesetzblatt, Part 1, page 35. In our conception, this is an extremely important decree because by virtue of it, the participation of the party in all legislation and in government appointments and promotions had to be undertaken exclusively by Bormann. He was to take part in the preparation, and we emphasize that, as well as the enactment and promulgation of all Reich laws and enactments. And further, he had to give his assent to all enactments of the Reich Länder, that is, the states, as well as all decrees of the Reich governors. All communications between state and party officials had to pass through his hands. And as a result of this law, we respectfully submit, Bormann is chargeable for every enactment issued in Germany after 24 January 1942, which facilitates and furthers the conspiracy. It will be helpful, I believe, to point out and to request the court to take judicial notice of a decree of 29 May 1941, Reichsgesetzblatt, Part 1, page 295. In this decree, Hitler ordered that Bormann should take over all powers and all offices formerly held by the defendant Hess. I request the tribunal to take judicial notice of another very important decree, that of the Ministerial Council for the Defense of the Reich, 16 November 1942.
Are these documents set out in the document book?
Yes, sir.
You haven't given us the reference.
That is true, sir. I recall from memory, although I do not have it in my manuscript, that the important decree of 24 January 1942 is our document, I believe, 2001 PS, sir. I now request the tribunal to take judicial notice of the important decree of the Ministerial Council for the Defense of the Reich, dated 16 January 1942, 1942, Reichsgesetzblatt, Part 1, page 649.
You're going too fast.
Sorry, sir. Under this decree, all Gauleiter who were under Bormann by virtue of his position chief of the party chancery, all Gauleiter were appointed Reich Defense Commissars and charged with the coordination, supervision, and management of the aggressive Nazi war effort. From then on, the party, under Bormann, became the decisive force in planning and conducting the aggressive Nazi war economy. On 12 April 1943, as is shown in the publication, the Greater German Reichstag, 1943 edition, page 167, our document 2981 PS, Bormann was appointed Secretary of the Fuhrer. And we submit that this fact testifies to the intimacy and influence of the defendant Bormann on the Fuhrer and enlarges his role in and responsibility for the conspiracy. We now come to the important point of Bormann's executive responsibility for the acts of the Volkssturm. I request the tribunal to notice judicially a Führer order of 18 October 1944, which was published in the official Völkischer Beobachter 20 October 1944 edition, in which Hitler appointed Bormann political and organizational leader of the Volkssturm. This is set forth in our document 3018 PS. In this decree, Himmler is made the military leader of the Volkssturm, but the organizational and political leadership is entrusted to Bormann. The tribunal will know that the Volkssturm was an organization consisting of all German males between 16 and 60. By virtue of Bormann's leadership of the Volkssturm, he was instrumental in needlessly prolonging the war with a consequential destruction of the German and the European war economy and a loss of life and destruction of property. We come now to deal with the responsibility of the defendant Borman with respect to persecution of the church. The defendant Borman authorized, directed, and participated in measures involving the persecution of the Christian church. The tribunal, of course, has heard much in this proceeding concerning the acts of the conspiracy involving the persecution of the church. We have no desire now to rehash that evidence. We are interested in one thing alone, and that is nailing on the defendant Borman his responsibility, his personal individual responsibility for the persecution of the church. I shall now present the proofs showing the responsibility of Borman with respect to such persecution of the Christian churches. Borman was among the most relentless enemies of the Christian church and Christian clergy in Germany and in German-occupied Europe. I refer the tribunal, without quoting therefrom, to document D75, previously introduced in evidence as USA Exhibit number 348, which contains a copy of the secret Borman decree of 6 June 1941, entitled The Relationship of National Socialism to Christianity. In this decree, as the tribunal will well recall, Borman bluntly declared that National Socialism and Christianity were incompatible. And he indicated that the ultimate aim of the conspirators... He indicated that the ultimate aim of the conspirators was to assure the elimination of Christianity itself. I next refer the tribunal, without quotation, to document 098 PS, previously put in as USA Exhibit number 350. This is a letter from the defendant Borman to the defendant Rosenberg, dated 22 February 1940, in which Borman reaffirms the incompatibility of Christianity and National Socialism. Now, in furtherance of the conspirators' aim to undermine the Christian churches, Borman took measures to eliminate the influence of the Christian church from within the Nazi Party and its formations. I now offer in evidence document 113 PS as USA Exhibit 683. This is an order of the defendant Borman, dated 27 July 1938, issued as Chief of Staff to the Deputy of the Fuhrer, Hess, which prohibits clergymen from holding party offices. I shall not take the time of the tribunal to spread this quotation upon the record. The point of it is as indicated. Borman issued an order forbidding the appointment of clergymen to party positions.
Perhaps that would be a good time to break off for 10 minutes.
Very good, sir. May it please the tribunal, we are dealing with the efforts of the defendant Borman to expel and exorcise from the party all church and religious influence. I offer in evidence document 838 PS as USA Exhibit 684. I shall not burden the record with extensive quotation from this exhibit, but merely point out that this is a copy of a Borman decree dated 3 June 1939, which laid it down that followers of Christian Science should be excluded from the party. The attention of the tribunal is next invited to document 840 PS, previously introduced in evidence as USA Exhibit 355. The tribunal will recall that this was a Borman decree of 14 July 1939, referring with approval to an earlier Borman decree of 9 February 1937, in which the defendant Borman ruled that in the future, all party members who entered the clergy or who undertook the study of theology were to be expelled from the party. I next offer in evidence document 107 PS, USA Exhibit 351. This is a circular directive of the defendant Borman, dated 17 June 1938, addressed to all Reichsleiter and Gauleiter, top leaders of the leadership corps of the Nazi Party, transmitting a copy of directions relating to the non-participation of the Reich Labor Service in religious celebrations. The Reich Labor Service, the tribunal will recall, compulsorily incorporated all Germans within its organization.
What was the number of that?
Excuse me, sir.
What was the number?
That was 107 PS, sir, USA Exhibit. I haven't the
No, that's sufficient.
684, sir.
Rechtsanwalt Bergholz als Verteidiger vom Gericht für Martin Bormann besteht. Der Herr Vertreter des Generalstaatsanwalts hat eben eine Reihe von Beweisurkunden vorgelegt, mit denen er beweist, dass auf Anregung Bormanns Mitglieder der Christlichen Union von der Mitgliedschaft aus der Partei oder bestimmten Organisation ausgeschlossen werden sollen. Ich bitte das Hohe Gericht, den Herrn Vertreter der Generalstaatsanwaltschaft zu veranlassen, mir zu erklären, warum und weshalb diese Tätigkeit, nämlich der Ausschluss christlicher Mitgliedschaft aus der Partei, ein Kriegsverbrechen sein soll, zu begründen. Aus dem Treilbrief kann ich das nicht entnehmen. Die Partei wird als eine als eine Verschwörung bezeichnet. Ist es denn auch ein Verbrechen, andere Personen von der Teilnahme an einer verbrecherischen Verschwörung zurückzuhalten? Wird das als ein Vergehen betrachtet oder was? Und weshalb ist der Ausschluss bestimmter Menschen aus der Partei ein Verbrechen?
Counsel will answer you.
If the tribunal will willingly accommodate argument at this stage, we find that the question put...
Only short argument.
Yes, sir. Admits of a short and, as it seems to us, easy answer. The point we are now trying to prove, and evidence is abounding on it, is that Bormann had a hatred and an enmity and took oppositional measures toward the Christian church. The party was the repository of political power in Germany. To have power, one had to be in the party or subject to its favor. By his efforts, concerted, continuing, and consistent, to exclude clergymen, theological students, or any person sympathetic to the Christian religion, Bormann could not have chosen a clearer method of showing and demonstrating his hatred and his distrust of the Christian religion and those who supported it.
I'm sorry, my fault. I say, counsel for Bormann can present his argument upon this subject at a later stage. The documents appear to the tribunal to be relevant.
With the tribunal's permission, I had just put in document 107 PS.
Yes.
And pointed out that it transmitted directions relating to the non-participation of the Reich Labor Service in religious celebrations. I quote merely the 4th and 5th paragraphs of page 1 of the English translation of document 107 PS, which read as follows, quote, "Every religious practice is forbidden in the Reich Labor Service because it disturbs the comrade-like harmony of all working men and women. On this behalf, every participation of the Reich Labor Service in churchly, that is, religious arrangements and celebrations, is not possible." End of quotation. The attention of the tribunal is next invited to document 070 PS, previously put in as U.S. Exhibit number 349. The tribunal will recall that this was a letter from Bormann's office to the defendant Rosenberg, dated 25 April 1941, in which Bormann declared that he had achieved progressive success in reducing and abolishing religious services in schools and in replacing Christian prayers.
Too fast.
Sorry, sir. And in replacing Christian prayers with National Socialist mottos and rituals. In this letter, Bormann also proposed a Nazified morning service in the schools in the place of the existing confession and morning service. In his concerted efforts to undermine and subvert the Christian churches, Bormann authorized, directed, and participated in measures leading to the closing, reduction, and suppression of theological schools, faculties, and institutions. The attention of the tribunal is invited to document 116 PS, USA Exhibit number 685, which I now offer in evidence. This is a letter from the defendant Bormann to the defendant Rosenberg, dated 24 January 1939, enclosing for Rosenberg's cognizance a copy of Bormann's letter to the Reich Minister for Knowledge and Education. In the enclosed letter, Bormann informs the minister as to the party's position in favor of restricting and suppressing theological faculties. Bormann states that, owing to war conditions, it had become necessary to reorganize the German high schools. And in view of this situation, he requested the minister to restrict and suppress certain theological faculties. I now quote from the first paragraph on page 3 of the English translation of document 116 PS, which reads as follows, quote, "I would appreciate it very much if you would restrict the theological faculties insofar as they cannot be wholly suppressed in accordance with the above statement. I request in this instance the omission of any express declaration to the churches or to other places, as well as avoiding of a public announcement of these measures. Complaints and the like must be announced, if they are to be replied to, in the fashion that these measures are being executed in the course of the economic plan of reorganization, and similar things are happening to other faculties. I would appreciate it very much if the professorial chairs thus vacated can be then turned over to the newly created fields of inquiry of the last years, such as national research, archaeological studies, etc. Martin Bormann. In our submission, what this document comes to is a request from Bormann. Please close down the religious faculties and substitute in their place Nazi faculties and university chairs with the mission of investigating racism, cultism, Nazi archaeology, the sort of thing in which the Hochschule, as which was so clearly demonstrated in the prosecution's case against plundering activities of the Einsatzstab Rosenberg. The attention of the tribunal is next invited to document 122 PS, previously put in as USA Exhibit number 362. The tribunal will recall that 122 PS is a letter from the defendant Bormann to the defendant Rosenberg, dated 17 April 1939, transmitting to Rosenberg a photostatic copy of a plan of the Reich Minister of Science, Education, and Training for the combining and dissolving of certain specified theological faculties. In his letter of transmittal, Bormann requested Rosenberg to take, quote, cognizance and prompt action, quote, with respect to the proposed suppression of religious institutions. I next offer in evidence document 123 PS, USA Exhibit 686. This is a confidential letter from the defendant Bormann to the Minister of Education, dated 23 June 1939, in which Bormann sets forth the party's decision to order the suppression of numerous...
686?
Yes, sir. To order the suppression...
686 PS?
I'm sorry, sir. That is the exhibit number. PS number is 123 PS.
123.
Yes, sir.
Would you go a little bit slower in announcing the numbers of the PS documents, because we've got to find them, you see.
Sir.
Yes?
This letter sets forth the party's decision to order the suppression of numerous theological faculties and religious institutions. The tribunal will note that the letter lists 19 separate religious institutions with respect to which Borman ordered dissolution or restriction. After directing the action to be taken by the minister in connection with the various theological faculties, Borman stated as follows, and I quote from the next to last paragraph, page 3 of the English translation of document 123 PS. Next to last paragraph, page 3 of the English translation of 123 PS, which reads as follows, quote, in the above, I have informed you of the party's wishes after thorough investigation of the matter with all party officers. I would be grateful if you would initiate the necessary measures as quickly as possible in regard to the great political significance for the Gaos concerned, which will be the result of every single case of such a combination. End of quotation. I next offer in evidence, without quotation, document 131 PS, 131 PS, as USA Exhibit 687. In summary, without quotation therefrom, this is a letter from the defendant Bormann to the defendant Rosenberg, dated 12 December 1939. 12 December 1939, relating to the suppression of 7 professorships in the nearby University of Munich. Now I deal briefly with the responsibility of Bormann for the confiscation of religious properties and cultural property. Bormann used his paramount power and position to cause the confiscation of religious property and to subject the Christian churches and clergy to a discriminatory legal regime. I offer in evidence document 099PS, USA Exhibit, document 099PS, USA Exhibit 688. This is a copy of a letter from Borman to the Reich Minister for Finance, dated 19 January 1940, in which Borman demanded a great increase in the special war tax imposed on the churches. I quote from the first two paragraphs of page 2 of the English translation of document 099PS, which read as follows, quote, "As it has been reported to me, the war fund of the churches has been specified from the 1 November 1939 on, at first for the duration of 3 months, at Reichsmarks 1,800,000 per month, of which Reichsmarks 1 million are to be paid by the Evangelical Church, and Reichsmarks 800,000 by the Catholic Church per month. The establishment of such a low amount has surprised me. I construe from the numerous reports that the political communities have to raise such a large war fund that the execution of their tasks, partially very important, for example, in the field of public welfare, is endangered. In consideration of that, a larger quota from the churches appear to be absolutely, what criminal effect is it to demand larger taxes from churchly institutions? By itself, this demand of Borman's, taken by itself, the prosecution would not suggest that it had criminal effect. But when viewed within the larger frame of Borman's demonstrated hostility to the Christian church and his efforts not merely to circumscribe but to eliminate it, we suggest that this document has probative value in showing Borman's hostility and his concrete measures to effectuate that hostility against the Christian churches and clergy. I next refer the tribunal to document 089PS, 089PS, previously put in as USA Exhibit number 360. The tribunal will recall that this was a letter from Borman to Reichsleiter Amann, dated 8 March 1940, in which Borman instructed Amann, Reichsleiter of the press, to make a sharper restriction in paper distribution against religious writings in favor of publications more acceptable to the Nazi ideology. Document 089PS, USA Exhibit 360. I next offer in evidence document 066PS, 066PS as USA Exhibit 689. This is a letter from the defendant Borman to the defendant Rosenberg, dated 24 June 1940, transmitting a draft of a proposed discriminatory church law for Danzig and West Prussia. This decree on its face is a direct abridgment of religious freedom. For in paragraph 1, I do not quote, but briefly and rapidly summarize, for in paragraph 1, the approval of the Reich Deputy for Danzig and West Prussia is required as a condition for the legal competence of all religious organizations. Paragraph 3 of the decree suspended all claims of religious organizations and congregations to state or municipal subsidies and prohibited religious organizations from exercising their right of collecting dues without the approval of the Reich Deputy. in paragraph 5 of the decree, the acquisition of property by religious organizations was made subject to the approval of the Reich Deputy. All credit rights acquired by religious organizations prior to January 1, 1940 were required to be ratified by the Reich Deputy in order to become actionable. I now offer in evidence document 1600 PS, USA Exhibit 690. This comprises correspondence of Borman during 1940 and 41 relating to the confiscation of religious art treasures. I quote the text of the second letter set forth on page 1 of the English translation of document 1600 PS, which is a letter from the defendant Borman to Dr. Posse of the State Picture Gallery in Dresden, dated 16 January 1941, which reads as follows, and I quote, "Dear Dr. Posse, enclosed herewith, I am sending you the pictures of the altar from the convent in Hohenfurther, near Krumman. The convent and its entire property shall be confiscated in the immediate future because of the attitude hostile to the state of its inhabitants. It shall be up to you to decide whether the pictures shall remain in the convent at Hohenfurther or be transferred to the museum at Linz after the latter shall be completed. I shall await your decision in the matter." Borman, end of quotation. The tribunal may know that in what is described as Hitler's last will and testament, he makes a bequest of all the art treasures he had in the museum at Linz. And from a legal point of view, he uses the euphemism, art treasures which I have bought. This document on its face suggests how certain, at least, of the properties, the cultural art treasures in the museum at Linz were acquired. Finally, as the war drew increasing numbers of German youth into the armed forces, the defendant Borman took measures to exclude and exercise all religious influence from the troops. The attention of the tribunal is invited to document 101 PS, previously put in as USA Exhibit number 361. The tribunal will recall that this is a letter from the defendant Borman, dated 17 January 1940, in which Borman pronounced the party's opposition to the circulation...
Wait, too fast.
Sorry, sir. This is a letter from the defendant Borman to the defendant Rosenberg, dated 17 January 1940, in which Borman pronounced the party's opposition to the circulation of religious literature to the members of the German armed forces. In this letter, Borman stated that if the influence of the church upon the troops was to be effectively fought, this could only be done by producing in the shortest possible time a large amount of Nazi pamphlets and publications. I now offer in evidence document 100 PS as USA Exhibit number 691. 100 PS 691 exhibit number. This is a letter from the defendant Borman to Rosenberg, dated 18 January 1940, in which Borman declares that the publication of Nazi literature for army recruits as a countermeasure to the circulation of religious writings was the, quote, most essential demand of the hour, end quote. I forbear from quoting from that document. Its substance is as indicated. I now request the tribunal to notice judicially the authoritative Nazi publication entitled Decrees of the Deputy of the Fuhrer, edition of 1937, and I quote from page 235 of this volume the pertinent and important decree issued by the defendant Borman to the Commissioner of the Party Directorate, dated 7 January 1936, the English version of which is set forth in the English translation of our document 3246. In this one sentence, Borman aims and directs the terror of the Gestapo against dissident church members who cross the conspirators. And I quote, "If parish priests or other subordinate Roman Catholic leaders adopt an attitude of hostility toward the state or party, it shall be reported to the secret state police, Gestapo, through official channels." Signed, Martin Bormann. End of quotation. By leave of the tribunal, I come now to deal with the responsibility of the defendant Borman for the persecution of the Jews. Again, the prosecution seeks not to rehash the copious evidence in the record on the persecution of the Jews, but rather to limit itself to evidence fastening on the defendant Borman his individual responsibility for the persecution of the Jews. Borman shares the deep guilt of the Nazi conspirators for their odious program in persecution of the Jews. It was the defendant Borman, we would note, who was charged by Hitler with the transmission and implementation of the Führer's orders for the liquidation of the so-called Jewish problem. Following the party-planned and party-directed programs of 8 and 9 November 1938, in the course of which a large number of Jews were killed and harmed, and Jewish shops pillaged and wrecked, and synagogues set ablaze all over the Reich, the defendant Borman, on orders from Hitler, instructed the defendant Goering to proceed to the, quote, final settlement of the Jewish question in Germany. That's Hitler to Borman, Borman issuing the instructions to Goering. The attention of the tribunal is invited to document 1816 PS, previously put in as USA Exhibit number 261. The tribunal is well acquainted with this document. It has frequently been referred to. The tribunal knows that document 1816 PS is the minutes of a conference on the Jewish question held under the direction of Goering on 12 November 1938. I quote only the first sentence of document 1816 PS, which fastens the responsibility upon Borman, and which reads as follows, quote, Goering speaking, "Gentlemen, today's meeting is of a decisive nature. I have received a letter written on the Führer's orders by the Chief of Staff of the Führer's deputy, Bormann, requesting that the Jewish question be now, once and for all, coordinated and solved in one way or another." End of quotation. The tribunal is well aware of the proposals, the discussions, and the actions taken in this conference that constituted the so-called settlement of the Jewish question. As a result of this conference, a series of anti-Jewish decrees and measures were issued and adopted by the Nazi conspirators. I offer in evidence document 069 PS, USA Exhibit 589. This is a decree of Borman's dated 17 January 1939, in which Bormann demands compliance with the new anti-Jewish regulations stemming and flowing from the Goering Conference just referred to, under which Jews were denied access to housing, travel, and other facilities of ordinary life. I quote the Borman Order, which appears at page 1 of the English translation of document 069 PS, which reads as follows, quote, after a report of General Field Marshal Goering, the Fuhrer has made some basic decisions regarding the Jewish question. The decisions are brought to your attention in the enclosure. Strict compliance with these directives is requested. Signed, Borman. End of quotation. In the interest of expediting the proceedings, I shall resist the temptation to quote extensively from the enclosed order in Borman's letter of transmittal. In effect, the crux of it is that Jews are denied sleeping compartments in trains, the right to give their custom to certain hotels in Berlin, Munich, Nuremberg, Augsburg, and the like. They are banned and excluded from swimming pools, certain public squares, resort towns, mineral baths, and the like. The stigma and the degradation and the inconvenience in the ordinary affairs of life prompted by this decree are plain on their face. I next request the tribunal to notice judicially the decree of 12 November 1938, 1938 Reichsgesetzblatt, Part 1, page 1709. Well familiar to this tribunal, for it was the decree which excluded Jews from economic life. This decree forbade Jews to operate retail shops, and it was a decree which went far to eliminate Jews from economic life. Now, Borman also acted through other state agencies to wipe out the economic existence of large sections of the Jewish population. With respect, I request the tribunal to notice judicially the authoritative Nazi publication entitled Decrees of the Deputy of the Fuhrer, edition of 1937, our document 3240 PS. 3240 PS. At page 383 of this publication, there appears a decree of the defendant Borman, dated 8 January 1937, reproducing an order of the defendant Frick, issued at Borman's instigation, denying financial assistance to government employees who employed the services of Jewish doctors, lawyers, pharmacists, morticians, and other professional classes. I shall forbear from quoting the text of that decree. Its substance is as given. Borman decree, quoting a Frick decree, issued at Borman's instigation, laying it down. Government employees who employ the services of Jewish professional classes will get no reimbursement or compensation. The decree is signed by Borman. After the outbreak of war, the anti-Jewish measures increased in intensity and brutality. If I may intrude, may it please the tribunal, for the aid of the translators, may I point out that I am now discussing from page 25 of the manuscript. After the outbreak of war, the anti-Jewish measures increased in intensity and brutality. Thus, the defendant Borman participated in the arrangements for the deportation to Poland of 60,000 Jewish inhabitants of Vienna in cooperation with the SS and the Gestapo. I have no doubt that the tribunal received this document in connection with the case against von Schirach. It is our 1950 PS, and on its face it points out, Lambert says, Borman has informed me, von Schirach, of your proposal to bring about the deportation. I limit myself to pointing out That single solitary fact. When Borman...
That light again.
Sir?
The light.
Sorry, sir. Shall I proceed, sir?
Go on.
When Borman succeeded the defendant Hess as chief of the party chancery, he used his vast powers in such a way that he was a prime mover in the program of starvation, degradation, spoliation, and extermination of the Jews, and we use those terms advisedly, who were subject to the draconian rule of the conspirators. I request the tribunal to notice judicially the decree of 31 May 1941, 1941 Reichsgesetzblatt, Part 1, page 297, which was signed by the defendant Borman and which extended the discriminatory Nuremberg laws to the annexed eastern territories. I request the tribunal to notice judicially the 11th ordinance under the Reich Citizenship Law of 25 November 1941, 1941 Reichsgesetzblatt, Part 1, page 722, signed by defendant Borman, which ordered the confiscation of the property of all Jews who had left Germany or who had been deported. I request the tribunal to notice judicially an order of Borman's dated 3 October 1941.
You haven't given us the numbers, the PS numbers of either the 31st of May 1941 or the one after that.
I confess dereliction of duty there, sir. These decrees, in their translated form, are all in the document form. I have not in my manuscript PS citation. However, in the brief now filed with, or soon to be delivered to the tribunal, these decrees are given with their PS numbers opposite.
Here's 3354 PS and 3241 PS.
It's very good of you, sir. Thank you. I request the tribunal to notice judicially an order of the defendant Borman's dated 3 October 1941, Volume 2 of the publication, Decrees, Orders, and Announcements, page 147. This is our document, rejoice to be able to say, of 3243 PS, 3243 PS, which announces a Ministry of Foods decree issued at Borman's instigation, which deprived Jews of many essential food items, all special sickness and pregnancy rations for expectant mothers, and ordering the confiscation of food parcels sent to the beleaguered Jews from the sympathetic outside world. Now request the tribunal to notice judicially the 13th ordinance under the Reich Citizenship Law of 1 July 1943, 1943 Reichsgesetzblatt, Part 1, page 372, signed by the defendant Borman, under which all Jews were completely withdrawn from the protection of the ordinary courts and handed over to the exclusive jurisdiction of Himmler's police. This is our document, 1422 PS. And with leave of the tribunal, we respectfully request the opportunity to underline the significance of that decree. In a society which desires to live under the rule of law, men are judged only after appearance and adjudication by a court of law. The effect of this decree was to remove all alleged Jewish offenders from the jurisdiction of the courts of law, turn them over to the police. The police were to have jurisdiction over alleged Jewish offenders, not the tribunals of law. The result of this law was soon forthcoming, a result for which the defendant Borman shares responsibility. On 3 July 1943, Himmler issued a decree, our document 3085 PS, 3085 PS, which I respectfully request the tribunal to take judicial notice. 1943, Ministry of Interior Gazette, page 1085, which charged the Himmler police and Gestapo with the execution of the foregoing ordinance closing the courts to the Jews and entrusting them to Himmler's police. Finally, sorry, sir. Finally, with respect to Bormann's responsibility for the persecution of the Jews, I request the tribunal to notice judicially a decree of Bormann's dated 9 October 1942, Volume 2, Decrees, Regulations, and Announcements, page 131132, which declared that the problem of eliminating forever millions of Jews from greater German territory could no longer be solved by emigration merely, but only by the application of ruthless force in special camps in the East.
What are you referring to there?
That, sir, is document 3244 PS. 3244 PS. One had desired at the outset, sir, to quote this decree in full as an irrefutable answer to a question put by defense counsel some days ago on cross-examination as to whether or not the anti-Semitic policies of the conspirators were the policies merely of certain demented or deviational members of the conspiracy and not the concerted, settled policy of the conspiracy itself. Time does not permit the full quotation of this decree, but with the indulgence of the tribunal, if I may offer the essence of this decree in a brief sentence or two. Borman starts out in this decree by saying, recently, rumors have been stimulated throughout the Reich as to violent things we are doing with respect to the Jew. These rumors are being brought back to the Reich by our returning soldiers who have eyewitnessed them in the East. If we are to combat the effect of these rumors, then our attitude, as I now outline to you officially, must be communicated to the German civil population. Bormann then reviews what he terms the 2,000-year-old struggle against Judaism, and he divides the party's program into two spheres. The first, the effort of the party and the conspirators to excommunicate and expel the Jews from the economic and social life of Germany. Then he adds, when we started rolling with our war, this measure by itself was not enough. We had to resort to forced emigration and set up our camps in the East. He then goes on to say that as our armies have advanced in the East, we have overrun the lands to which we have sent the Jews. And now, these emigration measures, our second proposal, are no longer sufficient. Then he comes to the proposal, the considered proposal of himself and the party chancellor. We must transport these Jews eastward and further eastward and place them in special camps for forced labor. And I quote now merely the last sentence of Bormann's decree. It lies in the very nature of the matter that these problems, which are in part very difficult, can be solved only with ruthless severity in the interest of final security of our people. Borman. End of quotation. With leave of the tribunal, I come now to deal.
It's signed, is it, by him? It's signed by Borman? Doesn't appear to be. I thought you said Borman.
That is what I said, true, sir. If the tribunal will refer, as it has, to document 3244 PS, it is clear that this is a Borman decree issued from the office of the Deputy of the Peer. It's true that on this translation of the decree, sir, Borman's name is not affixed, but in the original volume it is very clear that this is a decree of Borman's issued from the party chancellor. The prosecution so assures the tribunal and accepts responsibility for that submission. With leave of the tribunal, now come to deal with the responsibility of the defendant Borman for overt acts, for the commission, planning of a wide variety of crimes in furtherance of the conspiracy. The tribunal knows the powers that Borman possessed. That has been put in. Vast powers. Our point is that he used these powers, buttressed by his position as secretary to the Fuhrer, attending all the conferences at the Fuhrer's headquarters, that he used these vast powers in planning, the authorization, and the participation in overt acts denominated war crimes, crimes against humanity. The attention of the tribunal is invited to document L221, previously put in as USA Exhibit 317. L221, USA Exhibit 317. The tribunal knows that this document is a comprehensive report dated 16 July 1941, made by the defendant Borman just 3 weeks after the invasion of the territory of the Soviet Union by Germany. It is a report of a 20-hour conference at Hitler's field headquarters with the defendants Goering, Rosenberg, Keitel, and with Reich Minister Lambert. This conference resulted in the adoption of detailed plans and directives for the enslavement, depopulation, Germanization, and annexation of extensive territories in the Soviet Union and other countries of Eastern Europe. In his report on this conference, set forth in document L221, Borman included numerous proposals of his own for the execution of these plans. Later, the defendant Borman took a prominent part in implementing the conspiratorial program. The attention of the tribunal is invited to document 072 PS, previously put in as USA Exhibit 357. The tribunal will recall that this is a letter from the defendant Borman to the defendant Rosenberg, dated 19 April 1941, dealing with the confiscation of cultural property in the East. I quote merely the last two paragraphs of the English translation of document 072 PS, which read as follows, quote, "The Fuhrer emphasized that in the Balkans, the use of your experts," I parenthetically insert, that's the experts of the Einsatzstab Rosenberg, the plundering organization, end of intrusion. "The use of your experts would not be necessary, since there were no art objects to be confiscated. In Belgrade, only the collection of Prince Paul existed, which would be returned to him completely. The remaining material of the lodges, etc., would be seized by the organs of SS Gruppenführer Heydrich. The libraries and art objects of the monasteries confiscated in the Reich were to remain for the time being in these monasteries insofar as the Gauleiter had not determined otherwise. After the war, a careful examination of the stock could be undertaken. Under no circumstances, however, should a centralization of all the libraries be undertaken, etc. Signed, M. Borman. I now offer in evidence document 061 PS as USA Exhibit 692. This is a secret letter from Borman dated 11 January 1944, in which Borman discloses, we stress this, the existence...
What number was it?
Sorry, sir. 061 PS. In this letter, very important as it seems to us, Borman discloses the existence of large-scale operations to drain off commodities from German-occupied Europe for delivery to the bombed-out population in Germany. The tribunal knows that the Hague regulations and the laws of war permit the requisitioning of goods and services only for the use of the Army of Occupation and for the needs of the administration of the area. This proposal and this action represent the requisitioning of materials in occupied areas for the use of the folks at home, of the home front. I now quote the first two paragraphs
Yes.
I now quote the first two paragraphs of the English translation of Borman's letter of 11 January 1944, set forth in the English translation of our document 061 PS, which read as follows, quote, since the supply of textiles and household goods for the bombed population is becoming increasingly difficult, the proposition was made repeatedly to effect purchases in the occupied territories in greater proportions. Various district leaders, Gauleiter, proposed to let these purchases be handled by suitable private merchants who know these districts and who have corresponding connections. I have brought these proposals to the attention of the National Economic Minister and am quoting his reply of 16 December 1943 on account of its fundamental importance. The quote within the quote now comes, I consider it a specially important task to make use of the economic power of the occupied territories for the Reich. You are aware of the fact that since the occupation of the Western territories, the buying out of these countries has been effected in the greatest proportion. Raw materials, semi-finished products, and stocks of finished goods have been rolling to Germany for many months. Valuable machines were sent to our armaments industry. Everything was done at that time to increase our armament potentialities. Later on, the shipment of these important economic goods were replaced by the so-called distribution of orders from industry to industry. I shall end the quotation there, for the rest is not material to the point. In the course of the war, and this is of utmost importance in the view of the prosecution,
Is it clear that that was confiscation?
it was not suggested, sir, that this was confiscation. Our point was that the Hague regulations allow requisition in return for payment only for the needs of the Army of Occupation and for the needs of the administration of the occupied area. This represents, as it seems to us, a requisitioning program for the need of the home front. It was on that point that we offered. We come now to what the prosecution considers a most important point against the defendant Bormann. In the course of the war, Bormann issued a series of orders establishing party jurisdiction over the treatment of prisoners of war, especially when employed as forced labor. The tribunal knows that under the Geneva Convention of 1929, relating to prisoners of war are the captives, not of the troops who take them, or even of the army which captures them, but of the captive power. And it is the captive power which has jurisdiction over and responsibility for them. By the series of decrees now to be put in, Bormann asserts and establishes Nazi party jurisdiction over Allied prisoners of war. In the exercise of that party jurisdiction, he called for excessively harsh and brutal treatment of Allied prisoners of war. I now offer in evidence document 232 PS. 232 PS as USA Exhibit 693. This is a decree of the defendant Bormann dated 13 September 1944, addressed, will the tribunal please note, to all Reichsleiter, Gauleiter, and Kreisleiter, and leaders of the Nazi-affiliated organizations, numerous levels, that is, of the leadership corps of the Nazi Party, a decree establishing Nazi Party jurisdiction over the use of prisoners of war for forced labor. I quote the first 3 paragraphs of Bormann's order, set forth on page 1 of the English translation of document 232 PS, which reads as follows, quote, the regulations valid until now on the treatment of prisoners of war and the tasks of the guard units are no longer justified in view of the demands of the total war effort. Prosecution would intrude to ask the question, since when do the exigencies of the war effort repeal or modify the provisions of international law? End of our intrusion. Therefore, the Supreme Command, OKW, of the Armed Forces, on my suggestion, issued the regulation, a copy of which is enclosed. The following is cited for its contents. 1. The understanding exists between the Chief of the Supreme Command of the Armed Forces, OKW, and myself, that the cooperation of the party in the commitment of prisoners of war is inevitable. Therefore, the officers assigned to prisoners of war system have been instructed to cooperate most closely with the bearers of sovereignty, the Hoheitsstrager. The commandants of the prisoner of war camps have to detail immediately liaison officers to the Kreisleiters. Thus, the opportunity will be afforded the Hoheitsstrager to alleviate existing difficulties locally, to exercise influence on the behavior of guard units, and, this is the point we underline, to better assimilate the commitment of prisoners of war to the political and economic demands. End of quotation. Will the tribunal permit me to observe that on the face of this order, addressed Reichsleiter, Gauleiter, and Kreisleiter, addressed to these officials of the leadership corps, and in the terms of the order itself, Hoheitsstrager are referred to as cooperating measures. In this scheme, yes, sir. Certainly, sir. The tribunal has graciously permitted me to observe that, has graciously given me opportunity to observe that this decree is addressed to Reichsleiter, Gauleiter, Kreisleiter, and to the leaders of the affiliated and controlled Nazi organizations, all, as the tribunal knows, leaders within the leadership corps of the Nazi Party. The Kreisleiter is a pretty low level. That's a county leader. And on the face of the decree itself, the cooperation of the Hoheitstrager is directed, and the tribunal knows, under the evidence presented against the leadership corps, that Hoheitstrager range all the way from the Reichsleiter on the top down to and including 500,000 or so Blacklighters implicated. We submit in this decree. I next offer in evidence document D-163PS as USA Exhibit 694. This is a letter of the defendant Borman, dated 5 November 1941. That, sir, is D-163. Addressed, the tribunal will please note, to all Reichsleiter, Gauleiter, and Kreisleiter, the last just mere county leaders, transmitting to these officials of the leadership corps of the Nazi Party the instructions of the Reich Minister of the Interior prohibiting decent burials with religious ceremonies for Russian prisoners of war. I quote the pertinent portions of these instructions, beginning with the next to last sentence of page 1 of the English translation of D-163, which reads as follows, quote, to save costs, service departments of the Army will generally be contacted regarding transport of corpses, parenthesis, furnishing of vehicles, parenthesis, whenever possible. No coffins will be indented for the transfer and burial. The body will be completely enveloped with strong paper, if possible, oil, tar, asphalt paper, or other suitable material. Transfer and burial is to be carried out unobtrusively. If a number of corpses have to be disposed of, the burial will be carried out in a communal grave. In this case, the bodies will be buried side by side, but not on top of each other, and in accordance with the local custom regarding depths of graves, where a graveyard is the place of burial, a distant part will be chosen. No, we repeat, no burial ceremony or decoration of graves will be allowed. End of quotation. I now offer in evidence document 228PS, USA Exhibit 695. 228PS. This is a Borman circular dated 25 November 1943, issued from the headquarters of the Fuhrer, demanding harsher treatment of prisoners of war and the increased exploitation of their manpower. I now quote the Borman circular, which is set forth on page 1 of the English translation of document 228PS, which reads as follows, quote, individual Gau administrations often refer in reports to a too indulgent treatment of PWs on the part of the guard personnel. In many places, according to these reports, the guarding authorities have even developed into protectors and caretakers of the PWs. I informed the Supreme Command of the Armed Forces of these reports with the comment that the productive German labor population absolutely cannot understand it. If, in a time in which the German people is fighting for its existence or non-existence, PWs, hence our enemies, are leading a better life than the German working man, and that it is an urgent duty of every German who has to do with PWs to bring about the complete utilization of their manpower. The Chief of PW Affairs in the Supreme Command of the Armed Forces has now given the unequivocal order, attached hereto in copy form, to the commanders of PWs in the military districts. I request that this order be brought orally to the attention of all party office holders in the appropriate manner. In case that in the future complaints about unsuitable treatment of PWs still come to light, they are to be immediately communicated to the commanders of the PWs with reference to the attached order. End of quotation. The tribunal will note, of course, on the face of the decree, Borman instructs that these orders be communicated orally to all party officials, and that surely must include the members of the leadership corps of the Nazi Party.
Well, speaking for myself, I don't see anything particularly wrong in that communication.
On that point, sir, we submit that if you merely take a document which says we wish to utilize all the labor power of PWs in our control possible, and to get this result by suitable means, probably it tends to appear unexceptional. But viewing this document in relation to the other evidence in and to be presented, which show a concerted and settled policy by Borman and his co-conspirators to...
Well, it isn't necessary to argue it.
Yes, sir. Thank you, sir. The attention of the tribunal is invited to document 656 PS, previously put in as USA Exhibit 339. That's 656 PS, USA Exhibit 339. The tribunal will recall that this is a secret Borman circular transmitting instructions of the Nazi High Command of 29 January 1943, providing for the enforcement of labor demands on Allied prisoners of war through the use of weapons and corporal punishment. I quote a brief excerpt from these instructions, beginning with the third sentence of the third numbered paragraph of page 2 of the English translation of document 656 PS, which reads as follows. I quote, "Should the prisoners of war not fulfill his order, then he has," that's the guard unit, the guard personnel, "then he has in the case of the most pressing need and danger, the right to force obedience with the weapon if he has no other means. He can use the weapon as much as is necessary to attain his goal. If the assistant guard is not armed, then he is authorized in forcing obedience by other applicable means." End of quotation. This tribunal knows that under the Geneva Prisoners of War Convention of 1929, when prisoners of war prove derelict and refuse to carry out proper orders of the captive power or its forces, such prisoners of war are subject to court-martial and military proceedings as if they were serving under their own forces. Here is a decree which on its face authorizes or attempts to authorize guard personnel to use the rifle or other suitable means of violence. And of course, Your Lordship will understand that it was this type of document one had in mind when he suggested that the decree of Borman should be considered in the light of his other orders relating to the treatment of prisoners of war.
The tribunal will adjourn now.
The tribunal will recall that at the close of the morning session, I had been putting in a series of decrees of the defendant Borman in which he called for increasingly harsh and severe treatment of Allied prisoners of war. These instructions issued by the defendant Borman culminated in his decree of 30 September 1944. The attention of the tribunal is invited to document 058PS, previously put in as USA Exhibit 456. The tribunal will recall that this decree of the defendant Borman removed jurisdiction over all prisoners of war from the Nazi High Command and transferred it to Himmler. The decree also provided that all PW camp commanders should be under the orders of the local SS commander. By virtue of this order of the defendant Borman, Hitler was enabled to proceed with his program of inhuman treatment and even extermination of Allied prisoners of war. We now proceed to put in what the prosecution conceives to be extremely important and extremely incriminating evidence against Borman and the co-conspirators. That is, the responsibility of the defendant Borman for the organized lynching of Allied airmen. I offer in evidence document 062PS. 062PS, USA Exhibit 696. And I very respectfully request that the tribunal turn to this document. On its face, it is an order dated 13 March 1940 from the defendant Hess, addressed to Reichsleiter, Gauleiter, and other Nazi officials and organizations. In this order, these party officials are instructed by the defendant Hess to instruct all German civil population to arrest or liquidate all bailed out Allied flyers. I call the attention of the tribunal to the third paragraph on the first page of the English translation of document 062PS. In the third paragraph, Hess directs that these instructions, which I shall soon read, are to be passed out only orally to all, and will the tribunal please mark this, to all district leaders or Kreisleiter, Ortsgruppenleiter, cell leaders, and even the block leaders. That is to say, this order must be passed out by all the officials of the leadership corps in the Hoheitsstrager, ranging from Reichsleiter down to and including the Blockleiter. Now, turning the page of 062PS, the tribunal will find the instructions which Hess demanded be disseminated by the leadership corps ordering the lynching of Allied flyers. These directions are headed up about behavior in case of landings of enemy planes or parachutists. The first three instructions I omit as not material to the basic point now being made. Instruction 4 reads, and I quote, "Likewise, enemy parachutists are immediately to be arrested or liquidated." End of quotation. The document speaks for itself and requires no further comment from the prosecution. Now, in order to ensure the success of this scheme ordered by the defendant Hess, Borman issued a secret letter dated 30 May 1944 to the officials, will the tribunal please mark, of the leadership corps of the Nazi Party, prohibiting any police measures or criminal proceedings against German civilians who had lynched or murdered Allied airmen. This document, our 057 PS, has been previously put in and received by the tribunal in connection with the prosecution's case against the alleged criminal organization, the leadership corps of the Nazi Party. Now, may it please the tribunal, that such lynchings, organized, authorized, and consented to by defendant Borman, actually took place, has since been fully and indisputably demonstrated by trials by American military commissions, which have resulted in the conviction of German civilians for the murder of Allied flyers. I request the tribunal to take judicial notice of Military Commission Order Number 2, Headquarters 15th U.S. Army, dated 23 June 1945. This order is our document 2559 PS. 2559 PS. This order imposed the sentence of death upon a German civilian for violation of the laws and usages of war in murdering an American airman who had bailed out and landed without any means of defense. The tribunal will note that that order of the American Military Commission is dated 15 August 1944, and Borman's order was dated May 1944. I request the tribunal to notice judicially Military Commission Order Number 5, Headquarters, 3rd U.S. Army and Eastern Military District, dated 18 October 1945. This order is set forth in document 2560 PS. 2560 PS. This order imposed the sentence of death upon a German national for violating the laws and usages of war by murdering on or about 12 December 1944 an American airman who landed in German territory. We could cite further orders of American and other Allied military commissions sentencing German civilians to death for the lynching and murdering of Allied airmen who had bailed out and landed without means of defense on German territory. We think our point is made by taking the time of the tribunal to cite those two orders. As previously mentioned in the trial address, on 20 October 1944, when Nazi defeat in the war had become certain, Borman assumed political and organizational command of the newly formed Volkssturm, People's Army, by virtue of ordering the continued resistance by the Volkssturm, bears some responsibility for the resistance which prolonged the aggressive war for months. I come now, if it please the tribunal, to present the proofs showing that Borman authorized, directed, and participated in a wide variety of crimes against humanity in aid of the conspiracy. Borman played an important role in the administration of the forced labor program. I offer in evidence document D226, D226, USA Exhibit 697. This is a Speer circular of the defendant Speer, of 10 November 1944, transmitting Himmler's instructions that the party and the Gestapo should cooperate in securing a larger productivity from the millions of impressed foreign workers in Germany. I quote the second numbered paragraph of page 2 of the English translation of document D226, which reads as follows, quote, all men and women of the NSDAP, its subsidiaries and affiliated bodies in the works, meaning of course factories, will, in accordance with instructions from the Kreisleiter, be warned by their local group leaders. We intrude to say that means Ortsgruppenleiters, end of intrusion, and be put under obligation to play their part in keeping foreigners under the most careful observation. They will report the least suspicion to the works foreman, which he will pass on to the defense deputy, or, where such a deputy has not been appointed, to the police department concerned, whilst at the same time reporting to the works manager and the local group leader, the Ortsgruppenleiter, to exert untiringly and continuously their influence on foreigners, both in word and deed, in regard to the certainty of German victory and the German will to resist, thus producing a further increase of output in the works. Party members, both men and women, and members of party organizations and affiliated bodies must be expected more than ever before to conduct themselves in an exemplary manner. Now, in a word, the significance of that decree. It is true, it is a circular of Speer, reciting an arrangement between himself and Himmler. But the effect of the arrangement is to impose the onerous and continuous task of policing foreign workers on party members. A party which, as the tribunal knows, Bormann headed up as executive chief. Under the decree 24 January 1942, no such directive could have been issued without the participation of Bormann, both in its preparation and its enactment. I now offer in evidence document 025PS as USA Exhibit 698. This is a conference report dated 4 September 1942, which states that the recruitment, importation, mobilization, and processing of 500,000 female domestic workers from the East would be handled exclusively by Saukel, the defendant, Himmler, and the defendant Borman. I quote the first two sentences of the third paragraph of the English translation of document 025 PS, which reads as follows. First two sentences, third paragraph, English translation of document 025 PS. Quote, the Fuhrer has ordered the immediate importation of 400,000 to 500,000 female domestic Eastern workers from the Ukraine between the ages of 15 and 35, and has charged the General Deputy for Labor Mobilization with the execution of this action, which is to end in about 3 months. In connection with this is also approved by Reichsleiter Bormann, the illegal bringing of female housekeepers into the Reich by members of the armed forces or various other agencies is to be allowed subsequently. And furthermore, irrespective of official recruiting, is not to be prevented. End of quotation. And I now quote from the first sentence of the last paragraph on page 4 of the English translation of 025 PS. And this is the part that hooks in the defendant Borman with a scheme. That's the last paragraph on page 4 of the English translation of 025 PS. Quote, generally one gathered from this conference that the questions concerning the recruitment and mobilization, as well as the treatment of female domestic workers from the East, are being handled by the General Deputy for Labor Mobilization, the Reichsfuhrer SS, and the Chief of the German Police, and the Party Chancellery, and that the Reich's Ministry for the Occupied Territories of the East is not considered as competent or only as half competent. Party Chancellery is here mentioned in terms. Bormann was the leader of the Party Chancellery, as the Tribunal knows. Now, the defendant Bormann imposed his will on the administration of the German-occupied areas and insisted on the ruthless exploitation of the inhabitants of the occupied East. The attention of the tribunal is respectfully invited to document R36, previously put in as USA Exhibit 344. The tribunal is well acquainted with this document, for it has been referred to several times in these proceedings, and knows that this is an official memorandum of the Ministry for Eastern Territories, dated 19 August 1942, which states that the repressive views of the defendant Bormann with respect to the inhabitants of the eastern areas actually determine German occupational policies in the East. The tribunal recalls the now almost notorious quotation from this document R36, which purports to paraphrase and constitute the essence of Bormann's views with respect to German occupational policy in the East. So often has it been quoted that I shall resist the temptation to repeat it. But in essence, it comes to this. Bormann, in effect, says, the Slavs are to work for us. Insofar as we don't need them, they may die. They should not receive the benefits of the German public health system. We do not care about their fertility. They may practice abortion and use contraceptives, the more the better. We don't want them educated. It is enough if they can count up to 100. Such stooges will be the more useful to us. Religion we leave to them as a diversion. As to food, they won't get any more than is absolutely necessary. We are the masters. We come first. The document R36 we respectfully submit supports this as an accurate paraphrase and summary. The text of that document. The attention of the tribunal is next respectfully invited to document 654 PS, previously put in as USA Exhibit number 218. The tribunal will recall that this is a conference report dated 18 November 1942, embodying an agreement between the Minister of Justice and Himmler, entered into by Bormann's suggestion, under which all inhabitants of the eastern occupied areas are subjected to a brutal police regime in the place of an ordinary judicial system, and the agreement refers all disputes between the parties, Reich Minister for Justice and Himmler, to Borman for settlement. Now, because Borman issued these and related orders, we submit that he bears a large share of the responsibility for the discriminatory treatment and the extermination of great numbers of persons in the German-occupied areas of the East. With the indulgence of the tribunal, I put the substance of what I have been privileged to present in a few words. We have shown that Bormann, only 45 years old at the time of Germany's defeat, contributed his entire adult life to the furtherance of the conspiracy. His crucial contribution to the conspiracy lay in his direction of the vast powers of the Nazi Party in advancing the multiple objectives of the conspiracy. First, as Chief of Staff to the defendant Hess, and then as leader in his own name, party chancery, subject only to Hitler's supreme authority. These two positions he applied and directed total power of the party and its agencies to carry into execution plans of the conspirators. He used his great powers to persecute the Christian church and clergy, and was an unrepentant foe of the fundamentals of the Christianity with which he warred. He actively authorized and participated in measures designed to persecute the Jews, and his was a strong hand in pressing down the crown of thorns of misery on the brow of the Jewish people, both in Germany and in German-occupied Europe. As chief of the party chancery and secretary to the Fuhrer, Bormann authorized, directed, and participated in a wide variety of war crimes, crimes against humanity, including, but without limitation to, the lynching of Allied airmen, the enslavement and inhuman treatment of the inhabitants of German-occupied Europe, the cruelty of impressed labor, and the breaking up of homes, contrary to the clear provisions of the Hague Regulations, the planned persecution and extermination of the civil population of Eastern Europe. May it please this tribunal, every schoolboy knows that Hitler was an evil man. The point we respectfully emphasize is that without chieftains like Bormann, Hitler would never have been able to seize and consolidate total power in Germany, but he would have been left to walk the wilderness alone. He was, in truth, an evil archangel to the Lucifer of Hitler. And although he may remain a fugitive from the justice of this tribunal with an empty chair in the dock, Borman cannot escape responsibility for his illegal conduct. And we close with what seems to us an extremely important point. Borman may not be here, but under the last sentence of Article 6 of the Charter, every defendant shown on our evidence, every defendant in this dock shown on our evidence to have been a leader, an organizer, an inciter, an accomplice of this conspiracy is responsible for the acts of all persons in furtherance of the general scope of the conspiracy. And resting squarely on this proposition, we submit, even though Borman is not here, every man in the dock shares responsibility for his criminal acts. His name, and with this we close, the name of Borman is not written in water, but will be remembered as long as the record of Your Honor's tribunal is preserved.